Republican State Representative David Spiller of Jacksboro. Thank you so much. We appreciate it.
Thank you for having me.
So you were at the Fifth Circuit Court of Appeals for this hearing this week, and you're also the author of SB4.
Correct.
How did you think the state's lawyer did?
I thought he did a good job. I thought he covered the points that he needed to address some questions that the justices had raised at the previous hearing where there was oral argument. There were a couple of those answers that he didn't have complete answers, so he first off wanted to address those. Thought he did a good job of that. I thought he did a very good job of relaying the points that were made in the state's, in the state of Texas brief that were, all of those were very well done, very well briefed. I thought he touched on all those that he needed to, and then answered questions well. I thought he did a good job with that. And then at the end, he reserved some time for rebuttal and came in and addressed some of the things that the DOJ had not addressed and had not addressed in their reply brief and had not done anything else. So I thought he did a good job.
Do you think that he made up ground because he was, the state lost because they put a stay on it, right? So now do you think he made up any ground?
I think so, because, and I don't know what the outcome's going to be.
Sure.
It's up to that three-judge panel.
Right.
But previously, when we had a hearing a week or two before, the burden of proof on that was on the state of Texas. The burden of proof yesterday on the preliminary injunction is on the DOJ and the other plaintiff parties. So we have to keep that in mind. Burden of proof is a big thing in legal proceedings. And so, but I thought he did a good job. I thought he made the points that he needed to, and I feel good about where we are. Even if that ruling doesn't go in our favor, I feel comfortable with where we are and where we're headed.
Supreme Court.
Well, I think either the Supreme Court or if we had to have a rehearing in front of the entire panel rather than just the three-justice panel, I feel good about that too. So overall, I feel very good about SB4. I feel good, if not better, than I have about our chances with this thing, and I feel that it's not unconstitutional. I've said that all along, and for the reasons that I've stated, and even in the brief that was filed by the state of Texas, I think they made very good points about why we shouldn't even be here considering this issues such as standing and lack of a valid cause of action.
So let's talk a little bit about that, because each side seemed to try to make the most out of that point, the fact that there's so much uncertainty about the bill. On the one hand, the state of Texas is saying, yes, there's uncertainty, you haven't allowed it to go into effect, so therefore, what standing, not standing, but what cause of action, as you mentioned, does the federal government have to stop it? But on the other hand, the federal government was saying there's so much uncertainty, that's exactly why this law should not be going into effect.
Well, first of all, what makes it in part constitutional, in my view, is the fact that we're not in conflict with federal law, the federal government. We're not preempted. But part of that is because there are a number of statutes that the states work, just like we do with immigration-related issues, we work in conjunction with and cooperation with U.S. Border Patrol, ICE, and all of those entities. We cooperate with them daily. And so to say that there's some uncertainty, that's because anytime you have a partnership and you're cooperating together, you're assuming that the folks that you're cooperating with are going to continue to do so, and they're going to do things in a way and in a manner in which you are accustomed to doing them. So some of the uncertainty is because we're relying on that cooperation that we've had in the past. So the fact that there may be some uncertainty about specifics about how things are coordinated, that doesn't really bother me. As a matter of fact, I think that shows that we're not in conflict with the federal government. We're trying to work hand in hand with the federal government, just as we do right now with dealing with ports of entry.
As you know, there was a lot of discussion during this hearing over the state's ability to return someone to their home country. There was a lot of, obviously, disagreement over that from the beginning on this. So what was your assessment over that? That seemed to be a real focus point.
Well, the fact that there may be some uncertainty doesn't really bother me. In fact, it kind of supports what we're saying, is because what we've done in the past, as far as it being constitutional, because what we've done in the past is we work with the federal government. we work with the federal government daily with regard to immigration-related issues, law enforcement, everything from Border Patrol, ICE, those type of things. So to say that there's some uncertainty, that's because you have a partner that is suing you, but you have a partner that you're working with, and you assume that things are going to go a certain way. So the fact that there's some uncertainty or ambiguity about that, it's not in the statute itself, it's just the functionality of how we're going to do this, the procedure, the process. So the fact that there is some of that, to me, lends credit to the fact that it's the law, SB4, is not drafted in a way that it's in conflict with federal law. We're working with the federal government, and we look to continue to work with them related to returning people to ports of entry. So the fact that we're, that there's some disagreement or some uncertainty about that, I'm not concerned about that.
But isn't the issue, though, and the problem that it would be a state judge would be sending somebody back, whether they agree to it up front before being prosecuted or after they've been convicted and served their time behind bars? Isn't that the issue, that it's like if the state is allowed to do this in addition to the federal government, it just opens Pandora's box for anything to happen?
Well, again, I think that it's, what I've said all along is SB4 is constitutional, and one of the reasons for that is we're not in conflict with existing federal law. And so it's drafted exactly like the existing federal law. There's not been yelling or screaming or protest for the last 70 years while the federal law has been in place, and this law has been enforced for illegal entry, illegal reentry, and a order to return for decades. And to say that basically that now that you have that, there's nothing unfair about that, asking someone to go back if they arrived here illegally. So, but technically, I practiced criminal law for over 37 years, and I don't know of a single criminal statute that says that, not only after the law enforcement officer makes a probable cause determination, detains someone, arrests someone, and takes them to a jail or place or a magistrate to be magistrated and be told what their rights are and all those type of things, that you have the additional requirement, as we do here, the safeguard, to say that magistrate then makes his or her own probable cause determination, and then and only then would they make that determination that they could order someone back. And again, under SB4, on the front end, they only go back if they agree to go back. So I think that's a very fair process in lieu of further detention or prosecution. Now, on the back end, if they choose not to do that and say, we don't want to go back, but we want our case handled in this manner, then they're treated the same way as anyone else that's charged with a crime in the United States, whether they be a citizen or a non-citizen. And they're entitled to their day in court, and if they're tried, and if they're convicted, and if they're sentenced, then at the end of that sentence, then yes, they are ordered back, and we go through the same process, where the judge determines the manner and means in which they are returned to the U.S. port of entry.
Is it a problem if that country, for example, Mexico, says, no, we're not recognizing this? You can't return. The state of Texas can't return. Right.
And I've heard what the president of Mexico and some in interior Mexico have said. I'm not too concerned about that. Number one, our governor has memorandums of understanding, MOUs, with the 4 states that border Texas, Mexican states. And we have a very good understanding with them. They have cooperated with us. We have the full belief that they're going to continue to cooperate with us in that respect, to fight illegal immigration. And so if there's something additional that needs to be done, I have full faith and confidence in Governor Abbott to get that done. He has every right to do that under the U.S. Constitution, under our Constitution, to have MOUs with existing states. So I think that will happen. But the bigger issue is for Mexico to say that they're not going to take these people, I find to be very disingenuous, and that's a kind word to describe it, because they certainly let them in on the front end. They let them in at some other place in Mexico from countries, over 100 countries around the world, knowing full well what they're doing, where they're going. They've participated in that. Mexico has. They've facilitated it. They've acquiesced in that. And for them to now come and say, we're not going to take them back, I think that's silly. I think they're going to have to take them back, or we got a bigger problem. And so I don't know what President Biden would say that. I know what President Trump would say. Well, we're not asking permission. We're telling you we're sending them back, and you will take them back.
What was your reaction yesterday? Because the Solicitor General, the state's lawyer, seemed to suggest at one point that no, the people, the migrants would be the state would return the migrants to a legal port of entry. Did he try to rewrite the bill on the FAST? Because that's not in here.
No, actually, I believe it is in SB4 that says that the magistrate will determine how they get there and to which port of entry they go.
So that's an option.
Yes, that is an option, and they take them to the port of entry. In the bill, we avoided this idea that we would take them someplace else, someplace that's not a lawful port of entry, and that would not technically be the proper thing to do with regard to Mexico. If they came from Mexico, that we do that. So I think that's certainly proper, and that's in the bill, that they're taken to that port of entry.
And the judges asked, well, what's the point of that if the federal government may just release them again?
Well,
isn't that the danger here?
Again, we're trying to cooperate with the federal government. If the federal government says, if they mean what they say is we're doing everything we can to fight illegal immigration. If they truly mean that, then they will cooperate with us as they have in the past, and as they have in the past under previous administrations, and they will help us in this regard. We're not passing laws over and above what they've done. We're passing something in line with what they've done. We're trying to work with them. We're not trying to do something completely in conflict with them. So no, I think that they will, and I think they'll be ordered back, and we'll deal with it accordingly if something else comes up.
Last question, and I appreciate your time, and that is, if the whole process has gone through and the Supreme Court were to rule against Texas, then what? Has there been any discussion by yourself and other lawmakers about, all right, what's Plan B here?
There are another number of other things that we could do. There's some things, but I think here's my deal. I've not focused on that because I believe that what we have here is completely constitutional. And many of those that don't agree with that, I would say, you need to read the Arizona case. You need to read what it says, because there is a pathway there, I believe, for us to do exactly what we're doing. We're not trying to overreach. We're not trying to overstep. We took what happened in Arizona, we studied it, and we said, look, there's a pathway here for us to do exactly what we're doing. We're not in conflict with Arizona. We're not preempted by federal law. We're not in conflict with federal law. And as stated in the Attorney General's office brief, we have the absolute constitutional right, authority, and ability to secure our borders, secure our sovereign as a state. We have that right under the federal Constitution. We have it under the state Constitution. So I don't really have a Plan B at this point relative to this. I think Plan A is good. And unless and until it's not, then we're focusing on this.
State Representative David Spiller of Jacksboro, thank you so much for your time. We appreciate it.